The corona crisis has tremendously hit the travel industry on all levels, which means the suppliers as well as the package organizers. My presentation of today will focus on the relation between the package organizers and the local suppliers, such as hotel operators or air carriers. First of all, let's have a look of the termination rights under the Package Travel Directive for the traveler on the one hand and the organizer on the other hand. According to Article 12, paragraph 2, the traveler can terminate a contract due to unavoidable and extraordinary circumstances at the place of destination or its immediate vicinity, whatever that term may mean, which are significantly affecting the performance of the package or which significantly affect the carriage of passengers to the destination. So here we have a local restriction of the termination right with regard to the extraordinary circumstances. On the other hand, we have another termination right of the traveler in cases where the organizer is constrained to significantly alter any of the main characteristics of the travel services. So let's think of a cruise, for instance, when the cruise ship is not allowed to go to a certain harbor, a certain destination anymore, and therefore has to change its route. This could be a significant alteration of a main characteristic of the cruise and therefore also lead to a termination right of the traveler, and this kind of termination right is provided for in Article 11, Section 2. So if we look at the termination rights of the organizer, these are in Article 12, Section 3. The organizer is entitled to terminate the package if he is prevented from performing the contract because of unavoidable and extraordinary circumstances. So we can see that different from the situation of the termination by the traveler, we have no local restriction here. So wherever the unavoidable and extraordinary circumstances may happen, as soon as they prevent the organizer from performing the contract services, he is entitled to terminate the contract. But he has the obligation to notify the traveler without undue delay. The directive does not provide any rules for the relation between the organizer and the suppliers, because it focuses on the relation between organizers, retailers, and travelers only. So the legal relation between organizers and suppliers, like hotel operators or air carriers, will be governed by national law, as there is no other European directive which deals with this kind of legal relations. In at least some of these national laws, we find a legal doctrine which is called the doctrine of frustration of purpose. The first requirement to apply this doctrine is that we have a typical precondition for this type of contracts, which is not referred to by the parties in the contract because it had been taken as granted by the parties. And then we have an unforeseeable change of this precondition after the date of contract, which leads to the result that the contract purpose can definitely not be achieved anymore. And of course, this kind of typical precondition which has changed in an unforeseeable way must not be attributable to any of the parties invoking that situation. In Austria, this concept or legal doctrine is acknowledged by case law of the Austrian Supreme Court, in particular in travel law cases, such as cases dealing with terrorist attacks in a certain country or with the tsunami situation in the Far East. In Germany, we have an explicit provision in the German Civil Code in section 313 of the BGB. In the common law, so basically in the UK and Ireland, the leading case for that doctrine is Krell versus Henry of 1903, and it's one of these so-called coronation cases. It dealt with the coronation of King Edward VII, and Mr. Krell, who rented an apartment to watch the coronation scene on the street. Unfortunately, the date of coronation was changed after the rental contract was concluded. So in this case, the British court established the principle of frustration of purpose. If I understood that correctly, we have a similar concept acknowledged by a Spanish court called the desapiración de la base del negocio. Now let's look at different situations of a termination of contract in connection with the corona crisis. So first example is that we have a situation where the destination is affected maybe by a high infection rate or by a shutdown of public life, as we experience in many countries now. But the carriage to that destination is still possible. So what about the hotel reservation contract in such kind of situation? Is there a frustration of purpose? So if the infection rate is so high that for an average traveler it would be unreasonable to travel there and to spend the holidays there and go sightseeing there, then of course that might be a frustration of purpose, because the purpose of a hotel reservation contract usually is to provide the traveler with an accommodation where he can spend holidays and from where he can make sightseeing tours. Same applies for a situation when there is a shutdown of public life, because then sightseeing isn't possible anymore and the activities of the traveler are very restricted. So the purpose of the contract, of the hotel reservation contract between the organizer on the one hand and the hotel operator on the other hand, which is to satisfy the needs of the traveler, cannot be fulfilled, cannot be achieved anymore. It might be a bit different when there is no actually high infection rate or no actual closing of public life, but such closing has to be expected for the time of the package. In this situation, it is questionable whether one could already speak about a frustration of purpose. Last example is when there is an operation ban for the hotel. In this kind of situation, of course, the hotel cannot fulfill the contract anymore, so it's no question that the contract can be terminated by the organizer. If we look at the contract of carriage now, there might be a distinction to be made between scheduled services on the one hand and charter flights on the other hand. If we have a charter flight for the single purpose to carry the passengers of a certain organizer to a certain destination to enjoy their packages there, then probably if there is a high infection rate on that destination or a shutdown of public life, that could also impact the contract of carriage and could be regarded a frustration of purpose of this contract. It's much more difficult to apply this concept for scheduled services, because scheduled services usually have the only purpose to carry a person from A to B, and this purpose is not frustrated as long as people are allowed to travel and the air carrier is allowed to fly. So let's look at a situation now where the carriage is affected, maybe because of a travel ban, and because of the travel ban, the package contract is terminated by the traveler or the organizer. What about the hotel reservation contract in this kind of situation? Is there a frustration of purpose? So, the fact that people cannot go there from a certain country because no aircrafts can fly from there anymore has no direct impact on the hotel services, and it may be difficult in such situation to apply the concept of frustration of purpose. If we say that the purpose of the hotel contract is to allow a traveler to enjoy the package at the destination, like relaxation or sightseeing, this is not affected by a travel ban which makes the carriage impossible. If we look at the contract of carriage, of course, as soon as the service is impossible because aircrafts are not allowed to fly anymore, then the air carriers are not able to fulfill the contract and the contract can be terminated. If aircrafts are still allowed to fly, but the citizens of a certain country are not allowed to leave the country anymore because of restrictions imposed in connection with the corona crisis, we have a different situation. And the question arises whether the principle of frustration of purpose can be applied in such situation. It may be difficult to convince the courts. Let's go to the next example. We have a termination because the carriage is affected because of flight restrictions to be expected, but which are not yet implemented. So what about the hotel reservation contract? Like in the example before, it would be hard to apply the doctrine of frustration of purpose to these kind of situations, as long as the hotel operator is still able to provide the services and as long as at the destination it is still possible to have holidays and to do sightseeing. What about the contract of carriage? Is the service impossible if the restrictions are not yet implied but have to be expected? In one of my pending cases, we have a package to South Africa with a flight from Vienna to London and then London to Johannesburg and back. And the organizer, being afraid of flight restrictions, terminated the package before the first flight. And after the scheduled departure of that first flight, the last flight, the flight from London to Vienna, actually was cancelled. So the assumption of the organizer that not all the flights included in the package will be provided turned out as correct. But of course, at the time when the termination was made, when the carrier was notified about the termination, this was not the case. So let's see what courts will say in this kind of situation. I think that there are good arguments to say that a departure would not have been reasonable because there was a high risk of the group to strand in South Africa or anywhere and not be able to come back to Austria. If the termination is made in a situation where the carriage is affected because of a flight ban and the aircrafts are grounded, we talked about this situation before. Of course, with the hotel reservation contract, we still have the problem that it's unlikely to have a frustration of purpose there. But with the contract of carriage, if the carriage itself is impossible, then it can be terminated by the organizer. I have another case with a flight, a package including flights from Vienna to Abu Dhabi to Bangkok. And in this second case, because of a flight ban, the flight from Abu Dhabi to Vienna was cancelled before the departure of the first flight from Vienna to Abu Dhabi. So in this kind of situation, I think there is a clear right of termination for the organizer towards the air carrier, because it's already clear that not all the flights can be provided. What about other essential services being affected by the corona crisis, like a cancelled sports event, a cancelled theater event, or similar? Can the hotel reservation be terminated relying on the concept of frustration of purpose? I would say it depends. When the sporting event or cultural event was the clear purpose for the hotel reservation contract, then this might be the case, like in the coronation cases. What about the contract of carriage? Again, there might be a big difference between charter flights and scheduled services. If the charter flight's purpose was to visit a certain event, which then was cancelled, then there may be frustration of purpose. With scheduled services, it would be much harder to argue with that legal doctrine. Let's have a short look on the applicable law between the organizer and the supplier. First of all, we have to look whether the contract between these two contains a choice of law clause according to Article 3 of the Rome I regulation. In absence of such clause, the law of that country would apply where the service provider has his habitual residence, according to Article 4, Section 1b of the Rome I regulation, which means that in hotel reservation contracts, the law of the habitual residence of the hotel operator would apply, and in air contracts, air carriage contracts, the law of the country of the air carrier would apply. All in all, we can say that organizers and their suppliers seem to act as opponents rather than partners in this severe crisis. And I'll end my presentation with a quote by Aeschylus: "If you pour oil and vinegar into the same vessel, you would call them not friends, but opponents." Thanks for listening.